Yes, I do.
And I have here on the computer plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty.
I realize that we're still waiting for some testing.
Jermaine Young, 240916. I decided to quit saying DCCR. I'm over it. It's too much. All right, sir, you Jermaine Young?
Yes, ma'am.
And Mr. Young is charged with aggravated sexual assault of a child, and Mr.
This first case starts off heavy Jermaine Young, charged with aggravated sexual assault of a child. Notice how calm the courtroom is? That's because in these moments, every word matters. The judge is carefully confirming what's pending DNA results a crucial piece that can make or break this entire case.
Burbank, what is the announcement?
I think we're still waiting for some testing, Judge.
We are, Judge. I put a call in. I got a response on my DNA. That's the only thing that we had at CPS. We've received that.
Got that.
So this is the only thing that we're waiting on.
And did they give you any type of?
Follow through with them.
All right, let's do, we'll do, now that we've got CPS, that's the only thing we're waiting on. I'm going to do 60 days. And then hopefully we'll have some information. Obviously, when it gets close, if you can get back with them and see where we are. If we need to let them know some special setting to make it move up, then we'll see if we can get that done.
Yes, ma'am.
Stay in touch with Mr. Burbank. He'll let you know when you need to be back.
Yes, ma'am.
All right, we're free to go. Yes, sir. So I wonder where,
Sorry that I borrowed your time, but I can't tie it.
it's all right, you're good. All right, are you Maverick Neal? And Mr. Neal's charged with aggravated assault with a deadly weapon in 24 DCCR 2436. And what is the announcement?
Judge, we'd reset for me to try to contact the complainant. I'm not getting any answers for written correspondence.
Next up, Maverick Nealon, things heat up fast. He's facing aggravated assault with a deadly weapon, the drama here. The victim won't respond, but the prosecutor says they can still move forward. Can you believe that? Let's see how Judge West Raqual handles this one.
One of the different phone numbers my investigators know to locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we're set for trial, and I'll can double our efforts to locate her.
And you intend to go forward with or without?
I believe I can prove the case without her presence, Your Honor.
Okay, so if, sounds like there needs to be a rejection done, if there's not going to be, if he does not want to accept any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
All right, so Mr. Neal, in cause number 242436, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, I do.
And I have here on the computer plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. And with that type of probation, if you successfully completed it, the case would be dismissed and you wouldn't have a felony conviction. Do you understand? So I want to make sure that you do understand everything, because it's very important that after today, if I put your case on the trial docket, I won't accept this plea agreement. All right, so if you want the plea agreement, fine. If you are not guilty and you want to have a jury decide, that's fine as well. Mr. Nichols has stated earlier today that he intends to go forward with or without the complaining witness in this case. So we've talked about that. I don't want you to think that at some later date he intends to dismiss the case or something would change unless there's new evidence that comes forward. So if you don't want to take this 5-year deferred probation, that's fine. We'll put it on the trial docket, but I want you to make sure you understand that I will not accept this agreement after today. If you change your mind later and you want to enter a plea of guilty, then you can plea open to the court or to some other plea agreement. Do you understand that? And do you want to reject that plea agreement and have your case set for trial? It's your decision.
Sorry.
I mean, go ahead. I mean, if y'all need to talk some more, but
You don't want to plead, correct? Yes, you want to plead, or no, you don't want to plead? That's what we've been talking about outside. Yeah.
so you've been talking about it with Mr. Doyle.
Because I'm not understanding
What are you not understanding?
it's been 4 times, right?
I don't know about 4 times.
He's talking about the docket call.
Okay.
The state had indicated to me that they might have, or I indicated to the state rather, that the victim didn't want to prosecute the case.
Right.
He's never been able to get a hold of the victim.
Right.
To have her tell him that. He feels like he's been up here enough that I have the authority to make the state dismiss it, and I don't.
No, correct. So Mr. Doyle is doing everything.
And now James Ward steps up pleading guilty to robbery. But here's the twist. The charge was reduced from something more serious. Watch how Judge West Raqual carefully explains every consequence, making sure Ward knows exactly what he's agreeing to. This is justice in real time.
Everything he can with trying to negotiate with the district attorney. And it is legally possible for the state to go forward with the case without the complaining witness, and that is what they intend to do, according to Mr. Nichols, correct,
Yes,
Mr.
sir.
Nichols? So with or without her, they're going to present the evidence that they do have to a jury, if you go to a jury trial, and then that jury can decide whether or not you did or didn't do what they're charging you with. So today is the day to decide if you want to go to trial and let that jury decide whether she comes or not, case isn't getting dismissed, or if you want to enter a plea of guilty to the offense for that 5-year deferred probation. So you want to have a jury decide. Then I will place your case on the trial docket. Mr. Dole will begin preparation for trial.
Okay, do you have any ideas?
They'll send you that date. We're about
Okay.
3 months or so.
Okay.
Okay? Yes, sir. Thank you. You're free to
Thank
go.
you, Your Honor.
Mr. Bennett didn't have this setting on his calendar, and he hasn't made.
We're going on the lesser included robbery.
Thank you.
There are some misdemeanors that are out there that are gonna be, taken care of, so we're gonna need to determine the restitution on those misdemeanors as part of, if there's any.
Good morning, sir. Are you James Ward? And Mr. Burbank, will your client waive the formal reading of the indictment?
You will, Your Honor?
Mr. Ward, in cause number 240541, you're charged, the state has elected to proceed on the lesser included offense of a second-degree felony offensive robbery, and that's from April 11th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to pay restitution that would be determined between now and when we come back for sentencing, and there would be dismissals in the misdemeanor cases. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection to one.
It's admitted. Any evidence that Mr. Ward's not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll figure out restitution, and we'll come back later for sentencing. Yes, sir.
Your Honor, there's a case that was received by our office just a few weeks ago, not yet indicted, for evading with a motor vehicle. The offense date is from December of '24.
Okay.
Should that case get indicted, we will be running it concurrent with this.
Okay. If
I
it
don't
gets
think, I don't think a decision's been, or I don't think it's been presented to the grand jury yet.
All right. So obviously, if that case gets indicted, the understanding is that you would come in, we would do the same thing on that case, and you would have a probation that would run at the same time as this one. Is that your understanding? All right. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there, okay? We'll see you back at sentencing. Yes, sir.
Thank you, Your Honor.
Michael, in your case, 4 or 5.